Call the final case on the morning docket of 127949 in the matter of James L. Daniel. Counsel.
May it please the court, Amanda Voth on behalf of the Office of the Disciplinary Administrator's Office. Madam Chief Justice, I would request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
This is an original action in attorney discipline regarding the respondent, James Daniels, who has been licensed to practice law in the state of Kansas since 1993. I will first briefly talk about the procedural history of the case and then discuss the issues on appeal before talking more in depth about the recommended discipline. This case comes before you today following an evidentiary hearing that was held on January 4, 2024, which was bifurcated, and I'll talk about that here shortly, with the second hearing being held on June 10, 2024. The evidentiary hearing included a joint stipulation to some facts and exhibits. On January 4, the hearing panel found that Mr. Daniels violated 1.3 diligence and 1.4 and B, both communication. At the January hearing, the ODA argued Mr. Daniels' probation plan was not workable, substantial, and detailed, and that he had not established that he had been complying with each condition in the probation plan for at least 14 days prior to the hearing, as is required by Rule 227. The ODA also stated that if the panel was inclined, it would not be opposed to the panel setting the case out and allowing Mr. Daniels to develop a more robust probation plan. We recommended a 180-day suspension, but we were not opposed to a 12-month probation period if Mr. Daniels could come back with a probation plan that complied with Rule 227. This case is somewhat unique in that the panel issued an order and did decide to give Mr. Daniels a second chance and held the record open from January until June. Mr. Daniels did then submit 2 additional probation plans. And at the June hearing, the ODA's position was that even with the additional 5 months that Mr. Daniels had, his plan still did not meet the requirements of Rule 227. The ODA recommended that he be suspended for 180 days. The hearing panel issued its final hearing report and recommended also that Mr. Daniels be suspended for 180 days, but said that 150 days of that could be suspended if Mr. Daniels submitted a probation plan that was approved by our office. Mr. Daniels filed exceptions, the ODA did not, and both parties briefed the case. Then on November 27, 2024, not quite a year after the initial hearing, Mr. Daniels filed the 4th probation plan, which is titled the 3rd Revised. However, Mr. Daniels did not file an affidavit with the Supreme Court at least 14 days before oral argument regarding his 3rd Revised probation plan, which is required under Rule 227F. So because Mr. Daniels continues to fail to comply with Rule 227, most recently with subsection F2, that today the ODA is still requesting the 180-day suspension.
So on the probation plan that was submitted in November,
Right.
that was not served 14 days prior to the Supreme Court?
So Rule 227F2 requires that an affidavit of compliance.
Oh, an
be
affidavit
filed.
of compliance.
Right.
Okay. So is there anything else wrong with the affidavit of compliance from November? Or is just the whole issue for you that, or the ODA's office, that he didn't comply with giving it to us 14 days in advance?
There was not an affidavit filed, as far as I have seen. There was a 4th amended, or there was a 4th probation plan, which is the 3rd Revised, but there was not an affidavit of compliance. And then, so.
Okay, so yeah, that clarifies that for me. So on the 4th amended, which was titled the 3rd amended, or
Right.
whatever it is there anything that you take issue, or does the ODA's office take issue with in that probation plan if he were to have been complying with it?
Okay, so if he had filed the affidavit, as is required by the rule, then generally, no. Generally, I thought it was really good. I would say though, that in the third revised probation plan from November 27, it says that, and I'm reading on page 7 on it, it says that he will meet with Attorney Truesdale on or before December 20, and then they will meet again on January 13. And on the bottom of that page, it says that written reports will be submitted to our office commencing on January 21. So what I did receive was something from Mr. Daniels a week late on January 28. And it said that they met on January 24, last Friday. So it doesn't appear that they met December 20 and January 13, as he said he would in the probation plan.
Okay, and then, and in that time period, what was the issue about the original person that was gonna be the supervisory attorney became unavailable for some reason, or?
Right, so initially, in the second plan that was filed in February, it listed an attorney, James Scott. And then so Mr. Scott, as my understanding, was supposed to be supervising him February, March, April, part of May, and then on May 23, when they filed the third probation plan, which is the second amended, then
That was in May?
in May
Okay.
23rd, it said that he was no longer available.
Okay. And so did he identify a new person or not?
In the plan from November 27, he did, but that's the only thing I know about it, is what was in his probation plan filed November 27.
So as these processes happen in any case, where you've got proposed probation plans, there's this notion, and you even referenced it earlier, of the ODA's office approving a proposed probation plan, right?
That is what was in the final hearing report.
And am I right that that happens pretty regularly when you deal with probation plans?
I would say that does happen.
That there's an approval process?
I don't know that I would call it approval, but I mean, I do think that there are certain things that need to be in place. So I
Well-
mean, like,
Just help me understand how your office functions. This is a hypothetical case. There's a proposed probation plan. Like, how does the ODA communicate that it approves of the plan or that the plan is sufficient to move forward with?
in a normal case, that would be in the hearing. I mean, so there could be communication ahead of time saying, maybe you could consider doing this to beef up your
Okay.
probation plan, but
So is it unusual then for the hearing panel to talk about a plan that would come after the report?
so I don't have a lot of experience in that. So I am not sure.
I guess what I'm driving at is is there some practice that the ODA uses to communicate approval or disapproval of a plan?
I would say that it's probably case by case and person by person basis, but I
So it
mean,
could be just verbal, like there's no formalized way that the ODA issues a letter or
no.
a filing or.
No, and normally it should all come out during the initial hearing. Like normally it would be decided at the initial hearing. So this case is kind of an outlier in that there was a second hearing, and then we do have this final hearing report that references the approval. But no, there's no actual process. It should all just be taken care of on the record, in the hearing, first hearing. So as to the first issue, which I will go through here quickly. The first issue that the ODA addressed was Mr. Daniels' challenge to the hearing panel's factual findings. And I'll just briefly talk about the facts that support the clear and convincing evidence. Mr. Daniels did not, well, okay, let me back up. KW suffered to fall on August 14, 2019. And then about 12 and a half months later, on September 1, KW and Mr. Daniels signed a contingent fee agreement. Mr. Daniels obtained a majority of the medical records from KW within a couple of months in November 2020. And then on August 13, 2021, Mr. Daniels filed a petition in the Shawnee County District Court. Mr. Daniels did not file a summons And despite naming the defendants, the registered agents, and their addresses, he did not serve them. Mr. Daniels did not communicate to KW that he had filed the petition and did not send her a copy of the petition either before or after it was filed. He testified that he knew the status of the case, yet he did not check on the status of the case. And then on January 21, 2021, over 4 months after the case was filed, the court issued a notice stating that it would be dismissed if Mr. Daniels did not take further action to either prosecute the case or contact the court. Mr. Daniels did not do anything in the case, and he also did not communicate with KW regarding that notice. He neither told KW about the order nor that he failed to serve the defendants. And then over 2 weeks later, the court did dismiss the case. Mr. Daniels did know about the dismissal on that same date, but did not communicate that to KW. He testified that his plan was just to refile the case without talking to KW first. And he did not calendar a date in which it needed to be refiled. He also did not communicate to KW that he planned to refile the case, which deprived KW of having input in her own case. 5 weeks later, on February 11, KW emailed Mr. Daniels stating that she had phoned him many times with no response, and she inquired about the status. Mr. Daniels said that he would get back with her the following week. And on February 15, not having heard from Mr. Daniels, KW contacted the court and found out that her case had been dismissed. She testified that she was upset and felt bad because she did not know how to navigate the court, and that she had relied on Mr. Daniels to handle her case, and she no longer trusted Mr. Daniels. There was clear and convincing evidence that supported the hearing panel's findings. I will skip to, I have 1 minute left, so I'll skip to the issue about discipline. The hearing panel found that Mr. Daniels violated his duty to his client, that his mental state was that he engaged in a pattern of neglect and that caused injury to KW. And the hearing panel considered 4.42B and also 8.2 in finding that suspension was appropriate. The hearing panel also considered the aggravating and mitigating factors in this case. And one of the aggravating factors is the prior disciplinary history of Mr. Daniels. Despite Mr. Daniels saying throughout this case that his conduct was a mistake or a one-off, we know that he's been disciplined for similar misconduct in the past. He has been disciplined on 8 prior occasions, 7 times for 1.3 violations and 5 times for a 1.4 violation. That does include a 2007 suspension where he was suspended in Kansas for 1 year, then received reciprocal discipline in Missouri for 1 year. He was placed on probation and successfully completed probation in 2011.
Did you say that the suspension was supported by 4.42B? Is that the argument, suspension as opposed to other forms of discipline?
Yes.
It engages in a pattern of neglect and causes injury or potential injury to the client.
That's correct. That's what the hearing panel found. I would
Right.
submit that 4.42A is also supported by the facts, but the hearing panel did find 4.42B as the applicable mental state in this case.
How would you, I guess that you define the injury and not a timely prosecution, not in the loss of a claim. Is that how you would define injury in this context?
So the hearing panel found
Timely delivery of services, right? Or how would you define?
the hearing panel found that the injury was an unnecessary delay that resulted in a dismissal and KW's inability to refile and KW's distrust of attorneys.
But they were allowed to I mean, she had the opportunity to refile. Is that correct?
So the testimony from KW was that before Mr. Daniels, the question was, will you take my case, essentially. But then after the dismissal and everything happened with Mr. Daniels, then it changed to, I'm not going to go behind. That was a testimony. I'm not going to go behind Mr. Daniels. So it changed more to attorneys viewed it more as a malpractice rather than can we file your slip and fall. So I think that is where that's why the hearing panel found that she lost her ability to file, because the issue changed after the representation.
What? How did the issue change?
So my understanding from the testimony was that initially KW would go and ask an attorney, will you take my slip and fall case? So after after Mr. Daniels didn't serve the defendants and it was dismissed, then when she talked to an attorney, was her testimony, is that they said they didn't want to go behind him.
Go behind him. What does that mean?
My interpretation is that it was more of a malpractice issue, like they didn't want to go behind what a different attorney had done and or messed up in a case.
She was seeking services of a new counsel to pursue a malpractice claim rather than to refile her original
Oh, is
personal
that what she-
injury? Is
I
that
think-
what you're?
My understanding is that she was trying to get someone to still take the slip and fall, but that is not how attorneys viewed it at that, like anymore, after the representation and after it was dismissed.
Okay, I don't really follow it. I have a question. Okay, so on this suspension that what the panel recommended 180-day suspension with 150 of it stayed. And was there probation in that too?
They said 150 days of it being stayed if Mr. Daniels would submit a probation plan approved by the ODA.
Okay, and so and what's the ODA's position?
So the ODA's position is that because Mr. Daniels did not file an affidavit that is required, it says that a 227F says that a respondent who seeks to be placed on probation at least 14 days before oral argument must complete the following. And then 2A says file with the Supreme
Right.
Court.
Okay.
So,
got that.
okay.
Okay, so my bottom line is, what's the difference between 180 days with 150 days suspended and 180 days with 180 days suspended? I mean, that 30 days seems pretty darn significant because when you're suspended like that, okay, and you don't get probation, you have to notify all your clients. All your clients have to find new counsel. I mean, it is a huge disruption that affects not only Mr. Daniels, but also all of his clients and the courts that are hearing the cases, because then they're going to have to give continuances. And I just don't understand the reasoning of, I don't get that.
The hearing panel's reasoning.
Or yours, because that's kind of where you are too.
Well, so the ODA is still staying with the 180-day recommendation because 227 has not been complied with. So the hearing panel.
But you said at the beginning that if he submits one, then didn't you say that? Wasn't that your opening?
I don't think. I don't-
Okay, so at this point, he can't cure it, you're saying? He can't cure it today.
Right. I mean, it was not complied, like Rule 227F was not complied with. And it's a must under the rule. And so because of that, I don't think that probation is an option. And so.
And the reason that it's not working is because, number one, he had this, as I look at it, first evidentiary hearings, January 2024. In February 2024, he says, James Scott's going to be my guy. In May 2024, James Scott's no longer my guy, but he didn't identify anybody. But the second hearing hadn't even taken place by then, so he had no idea. And then in June 2024, the continued hearing took place. They issued their ruling in July of 2024. And then in November 2024, he submits this new and identifies the new supervising attorney. But your issue is, then he didn't meet with that attorney in December like he said he was gonna. And then he met with that attorney a week late in January, and he didn't file the affidavits. So that's the difference between closing your whole practice. It's because of that, right?
Our position is that he has not complied with Rule 227 throughout the proceedings, including most recently Rule 227F. And so even if he had complied with Rule 227F, there was, I mean, he didn't meet with his probation supervisor until a month after he said he would. He didn't submit the report when he said he would. So even if we don't have,
The report, you mean the affidavit of compliance?
well, that either. I'm talking about the report that he said he would submit on January 21 to our office, but submitted it a couple of days ago instead.
What report is that? I'm getting
Well,
mixed
it's
up.
the one that it's the one, it says respondent will be responsible for documenting the dates, duration, substance of each conference, and will submit written reports to the ODA at least once every 60 days commencing January 21. So I'm saying, even if we put aside the requirement of Rule 227F, then there are still issues that he's not, I mean, it's a too little too late, which has happened throughout the case. And the most recent too little too late was the Rule 227. And also, I mean, even what he says he's going to do in the most recent probation plan, he didn't do.
Okay, if the chief may indulge me with one more question, and that is, on the issue of, oh, no, I forgot the question. Sorry. Sorry, chief.
It's fine. Any others?
Okay.
Thank you.
Thank you.
I remembered it was then.
Don't take it personally.
May it please the court.
Yes, please.
Keith Cutler on behalf of the respondent, James Daniels. Let me start by saying that Mr. Daniels acknowledges that he has made some mistakes in this case. He should have gotten the defendants in the case served, and he didn't do that. He should have seen the email that ultimately led to the client's case being dismissed without prejudice. He should have seen that. He takes full responsibility for that and for his mistakes. But that's not why we're really here. Why we're here is because the punishment recommended by the hearing panel does not fit the conduct involved in this case. In cases where attorney's conduct has been similar and in some instances even identical to Mr. Daniels' conduct, this court has imposed much lighter discipline than what the hearing panel is recommending and what ODA is recommending. Now, Mr. Daniels recognizes that this court is not bound by its decision in other cases about prior discipline.
In the other cases you're referencing, did the respondent in those cases have the history of discipline that your client has?
Yes, as I recall from those cases, there was none of those cases was this their first appearance with the disciplinary matter. But however,
But we got 8. It's not just, that they had something before. We've got a real history here.
we have a history, but that history is more than 20 years old. And in the cases that this court has handled, which we cited in our brief, in those cases being the In re Ketter, In re Sutton, In re Pistotnik, where the conduct involved was 11 years prior, 7 years prior, 5 years prior. This court said those cases are too remote to be considered in the imposition of discipline stage. Mr. Daniels' conduct goes back 20 or more years, even to the 90s. That's the conduct that the hearing panel relied on in making this recommendation to this court, and that was wrong based on this court's prior decisions.
And let me just clarify that, that the panel used this not just as a, when they were considering it as an aggravating factor, they considered it not as just prior, but that as a pattern and practice, right?
Yes,
Okay, and so then from 2007 until, when did this happen? 2022 or what?
correct.
So they didn't consider the fact that, of that, as far as pattern and practice, this giant gap in the pattern and practice.
Absolutely, they did not consider that. And let me be clear about the 2007 date. There was discipline that occurred reciprocally in Missouri. And so the conduct behind the 2003, 2006, 2007 discipline was conduct from 2003, 2004. So it wasn't conduct that was going all the way up to 2007. We are talking about conduct that was 20 years old, that they skipped over that entire 20-year period of no complaints, no discipline, or no new discipline complaints, skipped over all of that to try to establish a pattern of conduct from 20 years before. The other thing they did to try to establish a pattern of conduct is they called Mr. Daniels out on a number of things, as you read in the hearing report, that are not violations of the rules of professional conduct. They called him out for filing the petition on the day before the statute ran. That's not a violation of the rules to file a lawsuit within the statute. And especially in this case, when Mr. Daniels got the case, more than half the limitations period had already run. He only had 11 months and he filed it within that time period, yet they dinged him for that. And that's not a violation of the rules of professional conduct. They called him out because they said he did not send a copy of the petition to his client for approval before he filed it. That's not required by the rules. And most attorneys don't do that, but yet they dinged him on that. They said that he never met with his client in person, completely ignoring the fact that the client lived in Topeka. Mr. Daniels' office is in Kansas City, Missouri, 70 miles away. This is a 65-year-old woman, and this all was happening in the aftermath of COVID. So of course, it made sense to conduct all of their business via telephone and via email. Yet they dinged him for not ever having met his client in person when that's not a violation of the rules. They called him out for not contacting the insurance company in the case. Well, there was already a letter, which is part of the record, that shows the insurance company denied liability. They weren't going to pay. There's nothing in the rules that requires you to beat that dead horse. They've already said they're not going to pay. Let's just move on with the lawsuit. They dinged him for that. So in addition to reaching over that huge 20-year gap of compliance with the rules to try to establish a pattern of conduct, they even reached outside of the rules of professional conduct to try to establish a pattern of conduct to support the ultimately and unduly harsh penalty that they're proposing of not only suspension, but suspension with only 150 days of the 180 days stayed.
What do you think what is your recommendation?
Respondent's
terms of just-
recommendation for discipline is a public censure. That is appropriate under the circumstances. It fits the guidelines, the ABA guidelines, and it's also consistent with this court's other decisions with similar conduct that we cited in Ray Bolton, in Ray Davison, in Ray Wiles. At most, maybe an admonition.
Do you agree that probation is off the table here because of the failure to comply with the rules?
I don't, because as Ms. Voth mentioned, there really is not a formal process for the ODA's approval. If there was an affidavit missing, again, this was filed back in November. If there was an affidavit missing, she could have sent me an email saying, hey, where's your Rule 227F affidavit?
Well,
And
do you agree that there was no affidavit filed?
Correct, there was no affidavit filed.
Okay.
And there were no updates filed, at least timely updates about the supervision and what's going on in the case that was part of the plan?
I'm not sure I understand the question, but I can tell you that a report was submitted. Yes, it was late.
I guess that's my question, that it wasn't a timely report. It was late and pretty much contemporaneous with this hearing today, when it just a couple days ago.
Yes, well, it was a week late. So the initial deadline to begin with would have been just days before this hearing. So it was just a week late. With respect to the practice supervisor, and I think this is fully set out in the briefs, the reason the initial practice supervisor was unable to continue was because he had a family emergency with his son. And he contacted Mr. Daniels just days before the probation plan was due to say, I'm not going to be able to do this. So this just isn't a situation where we had a practice supervisor and then, now we got to find somebody else. This was an emergency beyond Mr. Daniels' control. That necessitated him to try to find another practice supervisor. I think in our brief, we mentioned he's contacted 5 or 6 attorneys to try to help him out with this. So he's not sitting on his hands. He's not just blowing off this obligation. He has been really trying to comply with the requirement for a practice supervisor and not necessarily excusing the fact that the reports were late, but he's trying the best he can. The third thing I'd like to note for the court is that, as Judge Standers pointed out, the panel's recommendation that only 5 months of the suspension be stayed is just unnecessarily punitive under the circumstances. This is a case involving a negligent oversight. There was no dishonesty. There was no intent. There's no theft of client funds, no selfish motive. The client did not lose her cause of action. He gave her a ready-made petition that she could either file herself or get an attorney to file. So there was no harm to the client. Inasmuch as Mr. Daniels has not had any complaints in the last 20 years, this is not a situation where the public needs to be protected from him. And this court should be aware, as Justice Standers adequately pointed out, him being required to shut down his practice for a month will have a deleterious effect on the constitutional rights of his criminal clients and would require the rescheduling and reshuffling of the cases for his civil clients, not just with them, but with opposing counsel and with the courts. It would also have a devastating effect on Mr. Daniels' family and livelihood. The detrimental effect of shutting down his practice for a month is not just going to magically go away on the 31st day. The impact of him shutting down his practice and having to notify everybody, not being able to pay his staff, that will have a long-lasting effect, many, many, many months beyond just that 30 days. I will conclude by saying that the purpose, as this court knows, of attorney discipline is not to punish the attorney, but to maintain appropriate standards of professional conduct for the protection of the public and the maintenance of public confidence in the bar. Suspending Mr. Daniels and shutting down his practice for 30 days is clearly punitive in nature and is markedly inconsistent with the discipline that this court has imposed in similar cases, such as the Bowden case, Davison case, and Wiles. Mr. Daniels has admitted he's made some mistakes. He's cooperated in every step of the way in this proceeding. He's implemented the corrective procedures in the plan, and they've actually really helped his practice. He's going to talk to you in a minute with the court's permission about how it's really helped his practice and improved the way he does things, his communications with clients, which is what we want from attorneys. We want them to improve what they're doing. We don't want to knock them over the head and kick them when they can improve and make the improvements that he's made. He has found a replacement practice supervisor who he's been talking with, he's met with. He's on the path that we want him to be on to make sure we don't have incidents like this again. And so based on all of the attendant facts and all the circumstances and the law, as this court has pronounced in other cases, we think that a public censure is the correct punishment in this case, or at most an admonition. Would ask if the court is inclined to impose a suspension, that the stay be imposed for the entire period of suspension, not just a portion of it. And so if it pleases the court, Mr. Daniels would like to address the court at this time.
Certainly. Mr. Daniels.
Good afternoon, Your Honors. My name is James Daniels, and obviously I am the respondent in this case. I operate a law firm in Kansas City, Missouri, and I specialize in personal injury cases and criminal cases. I'm available to my clients in person by telephone, by Zoom, by text, and many of them have my cell phone. This case that we're discussing today came to me in September of 2020. Obviously, the height of the COVID pandemic, a time when all of us were dealing with some very unusual challenges. This client came to me essentially pleading that I take her case because no one else would take it. It was not a good case. It's a trip and fall case with no surgery, no bills, in a conservative venue. The reason she told me that lawyers were telling her they did not want to take the case was these Kansas laws. It's a trip and fall case. It's the 6258, the comparative fault statute, in which provides that if that plaintiff is 50% at fault, there's no recovery. That was my interpretation of what the lawyers meant when they were telling her these Kansas laws are the reason they did not want her case. It was a bad case. Nevertheless, I took it. When you take a case, the standard is the standard. I did not meet the standard. I didn't get the defendant served, and I missed the email. The standard is the standard. I didn't meet it, and I'm sorry for any inconvenience or undue stress that was caused to this client by this this activity or the failure to get the defendant served. So we know what the allegations are and what the problems were in this case. So if the court is pleased, I will tell you what I've done to correct the problems. With regard to deadlines, and to answer your question, Your Honor, about the DA being made aware of what I was doing, this was everything that I'm about to tell you now was part of the testimony at one of these hearings we had. They suggested I get practice management software, which I did. The software is called Clio. The practice management software has ticklers that will kick out deadlines. When I file a lawsuit, I put in that tickler for statute of limitations, 180 days. It's 180, 120, 90, 60, 45, 30, 15, 10, 7, and 1. So from 6 months before any statute runs, I'm getting the tickler every. Then with regard to service of process, it's every 90 days. It starts at 90, 90, 60, 45, 30, 15, 10, 7, 1. So I have put that in place. I've filed 4 lawsuits since this case came about, and I've obtained service in every one of them in a timely manner, usually within days, because now when I file a lawsuit in Kansas, I file the summons at the same time. So when the stamp comes back, as soon as the clerk stamps the summons, the lawsuit goes out. So with regard to emails from the court communications, any court communications that come to me now come to 3 separate emails. They come to my firm email, they come to my personal email, and they go to my assistant's email. So everybody, there's emails, 3 different emails that anything that comes from the court is going to go to. So that's what I've done in terms of trying to ensure that I don't overlook any correspondence from the court. So with regard to, the practice managers, I think Justice Stegall was kind of touched on this. With Mr. Scott, he had an emergency, and so I didn't want to burden him with all of these meetings and taking up all of his time before not even knowing whether this probation plan was going to be approved or not. They made the suggestions. I went out and put these measures in place to alleviate the problems. The The probation plan sets out certain intervals, minimal intervals to which I'm supposed to contact clients. If it's a criminal client, it's every 30 days at least. But with criminal cases, they move pretty rapidly. There's hardly going to be a 30-day time period when something is not happening. When I leave this courthouse today, I'm going to Geary County to meet an incarcerated client. With regard to civil clients, it's every 60 days because they can slow down. But still, I haven't had an instance yet in a case where there was not some communication in a shorter period of time. In this particular case, the client testified that she had at least 16 or 17 telephone calls with my office. Whether that was with me or my assistant, the communications occurred. When she reached out to me by email, as the record reflects, and you guys have read the briefs, the communication was immediately forthcoming. There's no communications issue in this case, and I generally try to not allow that to happen. So I missed the deadline. I missed the service process deadline. There's no doubt about it. But I put the measures in place to ensure that it doesn't happen again. And I'm hoping that the court will see, the value in that, and also see that in similar cases that this court has handed down, there has been no suspension in cases like this. There's been no suspension in cases like this. There's no dishonesty. There's no money involved. This client had plenty of time to refile her lawsuit. She chose to, but she didn't do that. She chose to go look for a malpractice lawyer who apparently didn't, and that is the person who guided her toward the bar complaint. When she started contacting me, I could tell she already had another lawyer. So that's why I said, hey, here's the complaint, the petition. It's in Word format. Your lawyer can change it or you can file it pro se. But I knew she had another lawyer. But the purpose of her going to another lawyer was to, and that was before the case was even, before she even knew the case was dismissed. I'm not sure, what was going on there. But in any event, the other thing that I do with regard, so that doesn't happen, with regard to petitions, when I file a lawsuit, I send the client a letter that says, please find and close the petition filed on your behalf on this date. So they have the petition once I file it. So I think I've tried to address every issue that the disciplinary administrator has raised in this case, the communications issues, the diligence issue, even things that aren't required, like sending that petition out to the clients. I've done everything except comply with Rule 27's stipulations of filing the affidavit. She received a report from me yesterday about my meeting with Mr. Truesdale on the 28th. She also received a letter from Mr. Truesdale. So she knows that all of that is in place. The technicalities of the Rule 227 I didn't comply with. But based on prior precedent set forth by this court, probation is not even an appropriate sanction in this case. But if the court decides that it is, I will cure, I don't know if there's a mechanism to cure those issues, but the DA did not even she did not argue that the plan wasn't workable, that it didn't have the appropriate measures in place. That's not the argument. The argument is on the technicality, you should be suspended because you didn't comply with sending the affidavit and you didn't do these things on time. That's not justice. That's retribution. In any event, I believe I've made all the points I came here to make today. Unless the court has questions, I'm very happy and very open to answer any questions you may have.
I see none. Thank you, Mr. Daniels.
Thank you, Chief.
Ms. Foe?
There are three things that I'd like to quickly address. First, The ODA's argument, the entire time that this case has been going on since the first proceeding, second hearing, and now, is that he has not complied with Rule 227. There are different subsections that he hasn't complied with, but that is not something that is new today. It has
Can I,
always been.
on that point,
Yes,
I understand the argument about the failure to comply while the hearing panel was active. As I read 227, there's no provision at all for probation to be considered, to be initiated after the hearing report's filed.
correct.
So whatever happened after this, all the November proposed plan and there's no provision in the rule for any of that, is there?
There's not.
Okay, should we hold, are you asking us to hold the failure to comply with 227 post-hearing report against the respondent? When
So-
that doesn't even exist, right?
Well, okay, so you're saying that 227F though still requires that if a respondent is seeking probation, that he or she files an
But
affidavit.
that references the plan that is filed and proposed 14 days before the hearing.
Right.
That's not what we have here.
No, that is true.
So I guess I'm just wondering, it seems as though this is sort of an ad hoc thing that is not governed by any rule.
I would agree.
There's no
with that.
provision in the rules for this.
There's not, right, there aren't
I would
provisions.
maybe suggest that whatever happened with this third or fourth probation plan is kind of irrelevant.
I would agree.
Okay.
Real quickly, there was some discussion about the hearing panel's finding of one aggravating factor of that being a pattern of misconduct. And I just wanted to quickly touch on that to say that they mentioned briefly, not only has Mr. Daniels repeatedly engaged in misconduct involving lack of diligence in communications, but continually did that throughout this case as well. And they cited specific instances of that. So it was their pattern of misconduct was not only based on their prior disciplinary history. The last thing I wanted to touch on was a case that has been more recently decided. I know Mr. Cutler has cited some cases from 1988 and 2003, I think is the most recent one. But there was a case that's in Ray Sedgwick, and that was about 13 months ago. It's from December 29 of 2023, where this court did impose a suspension for 1.1, 1.3, and 1.4 violations. And in that case, it's a little bit different because the probation officer testified, and so he got probation, but he received an underlying suspension term. If there aren't questions, then I'm out of time.
See no question. Okay, thank you. Thank you to all of you for your statements and your arguments today. The court will take this matter under advisement.